Hello, I'm John Landy, Isidore Loeb Professor Emeritus at the University of Missouri Law School. I graduated from law school in 1980. In the mid-1980s, I had a law and mediation practice. After that, I earned a PhD in sociology, focusing on the sociology of law and dispute resolution. In 2000, I began teaching at Missouri. I retired from teaching in 2015, but I've continued writing and giving presentations to practitioners, academics, and students. In February 2025, I became fascinated with the potential of artificial intelligence, and I've been exploring it ever since. That led me to create an AI tool called the Real Practice Systems Negotiation and Mediation Coach, or RPS Coach for short. It's based on the ideas, research, and teaching tools I've developed over the past 40 years, especially my work on mediation, negotiation, and legal education. So why is this relevant now? AI tools like ChatGPT have grown extremely powerful in just the past few years, and they're quickly becoming part of the legal and dispute resolution practice. For mediators and lawyers, this creates a big opportunity, not just to save time, but also to improve your preparation, strategy, and client support. In this video, I'll give you a basic introduction to AI. I'll also demonstrate how you can use RPS Coach in your work. Let's get started. Here's the roadmap for what we'll cover in this video. First, we'll look at how you can use AI in your practice, whether you're managing mediation sessions, advising clients, or trying to improve their decision-making. Next, I'll introduce real practice systems theory. That's the framework I developed to help practitioners become more intentional in how they approach negotiation and mediation. It's about having a comprehensive system for analyzing these processes. Then we'll look at RPS Coach itself. You can think of it as accessing my 40 years of experience without having to track me down in person. I just call it Coach. Like any good coach, it gives useful feedback but leaves the decisions up to you. Finally, I'll show you a demonstration of how Coach actually works so you can see how you might use it in your practice. By the end of this video, you'll have a clearer picture of AI in general and a sense of how you can use Coach and other AI tools. So let's look at how AI can help mediators and lawyers in your day-to-day practice. First, it helps you work faster and smarter, not harder. You can streamline routine tasks, brainstorm ideas, and draft language. You can use it at any stage, whether you're preparing for a negotiation or mediation, actively working through one, or reflecting afterward to improve. This can mean organizing your thoughts, reviewing documents, and planning strategies. You can use it to help clients understand the process, to think through risks, clarify options, develop strategies, and anticipate reactions. This can build client confidence. When clients are well prepared, they feel more capable of making good decisions. AI can give you access to specialized knowledge, such as detailed checklists. You can ask for what you need in specific cases and get it in just a few seconds. It's also great for debriefing difficult cases. You can consider what went well, what didn't, and what you might do differently next time. Ultimately, the value you get from AI depends on how thoughtfully you use it, a skill you can build over time. Here's some guidelines for getting the most out of AI. First, use it with care. AI isn't perfect, and sometimes it's confidently wrong. Second, ask clear, specific questions. The more precise you are, the more likely you are to get a useful answer. Third, treat it as a dialogue. Don't just take the first response and stop there. Plan to follow up, refine your question, and explore different angles. Fourth, check whether the responses are accurate and useful. especially if you plan to rely on them. AI can save time, but it still requires human review. Be sure to protect confidentiality. Avoid providing names or other personally identifying information. One of the most important skills in using AI is writing good prompts. Here's a simple 5-step formula. First, identify your role. For example, I'm a mediator, or I'm a lawyer representing a client in mediation. Second, state your task. For example, I need help developing questions for a call with a lawyer before a mediation session, or I need to decide how to respond to the other side's last offer. Third, give context. That might be something like, this is for a mediation involving a workplace conflict, or this is for a negotiation scheduled for next week. Fourth, specify the kind of output you want. For instance, I'd like a checklist, or please draft an email. And fifth, add any important details. Include facts about the case, your approach, or concerns about tone. Give the AI tool enough information to understand your goal so that it can help you achieve it. If it's relevant, include your jurisdiction or particular techniques you plan to use. For example, a mediator might use a prompt like this. I'm a mediator in a session where we're stuck and tensions are rising. I need help thinking through ways to reframe the conversation, manage emotions, get the parties to consider realistic options. And remember, if you don't get the response you need, tell the AI tool why the answer didn't work and what kind of response you're looking for instead. Now that we've covered how to write effective prompts, let's look at a few examples to give you ideas about what you might ask an AI tool. Mediators can use AI to enhance your preparation, creativity, and reflection. You might ask for help deciding what to discuss with parties or lawyers before a session, or how to help parties better understand each other's perspectives. Or you could brainstorm settlement options beyond lump sum payments, or get ideas for responding when a lawyer is not cooperating. After a tough case, you might reflect on what didn't go well and what you can learn from it. The point isn't just to get an answer, it's to use AI as a thinking partner to work through problems, test ideas, and improve your work. Lawyers can use AI tools to communicate with clients, prepare for sessions, and reflect on their practice. Here are some examples of prompts that lawyers might use. You might ask AI to help explain to a client the intangible costs of continuing to litigate, such as stress, distraction, or reputational harm. You might ask it to draft a mediation memo that you can tailor to your case. You might use it to develop a realistic bottom line by combining the expected court outcome, litigation costs, and your client's intangible costs by continuing to litigate. Or you may want help dealing with your counterpart and ask how to encourage the other lawyer to be more reasonable. These are just a few starting points. You can adjust them to fit your client, your case, and your goals. Parties also can use AI to prepare and make informed decisions in mediation and negotiation, all of which can promote better outcomes. Self-represented parties may find AI especially helpful. Of course, it's not a lawyer and doesn't provide legal advice, but it can suggest ideas and provide feedback about possible strategies. Even if parties have lawyers, they might ask AI how the mediation process works, what the mediator will do, and what preparation will help them feel confident. It also can help them think through how to respond to offers. And they may ask whether it makes sense to settle or keep litigating. Mediators and lawyers can benefit by understanding the Real Practice Systems Framework, a tool for helping you think about your work. We'll focus on mediation practice systems, but lawyers also develop systems for representing clients in mediation and handling other work. Mediators develop regular systems, including actions before, during, and after mediation sessions. Some are conscious strategies, and others are routines that they hardly notice. These systems are affected by many factors, including a mediator's history, values, motivations, knowledge, and skills, as well as the kinds of cases and parties they typically see and the behavior patterns they regularly encounter. For example, a mediator who is a family lawyer might bring knowledge of divorce law, sensitivity to the emotional aspects of family conflict, and a desire to help parents protect their children. This mediator might routinely ask clients to bring information to the first mediation session about their parenting schedules, financial situations, and priorities. That way, they'll be ready to start as soon as the mediation session begins. If the mediator handles a lot of high conflict disputes, they may develop strategies for setting clear process guidelines, managing interruptions, and de-escalating angry arguments. By contrast, a mediator who primarily handles workplace disputes might draw on a background in human resources, a knack for communication coaching, and a focus on preserving professional relationships. This mediator's routine might include preparation meetings to help each party identify their concerns. In both cases, these systems grow out of the mediator's experiences, values, and goals. Reflective practitioners periodically revisit them to improve their techniques. AI tools like Coach can help practitioners turn unconscious habits into deliberate choices. Now let's look at a more detailed illustration of how these practice systems actually work in mediation. This chart shows a typical process when parties are represented by lawyers and they prepare before the mediation session. That's not always the case. Sometimes parties represent themselves and there's little or no preparation. The 4 rows represent stages in the process. Many people focus only on the mediation session, but the earlier stages often are just as important, if not more so. And mediation also may involve follow-up activities after the session ends. The 3 columns show the roles of lawyers, parties, and mediators. In the first stage, shown in the light blue cell, lawyers interview clients to understand their goals and interests and to start forming a strategy. They'll investigate the facts, research the law, and evaluate likely court outcomes. If mediation seems like a good option, they'll discuss it with the client and reach out to the other lawyer to see if they're interested. If both sides agree, the lawyers choose a mediator. Mediators work in a competitive market, so they may shape their techniques to get repeat referrals. After lawyers retain a mediator, the mediator acts as a stage manager, coordinating with lawyers, reviewing any written submissions, and planning how the process will work. That's the yellow cell. Lawyers, in turn, prepare their clients for what to expect in mediation and how to pursue their goals. During the mediation session, the mediator manages the process. That's the green cell. The goal is to help parties reach a mutually acceptable agreement if possible, shown in the orange cell. Afterward, the follow-up depends on the outcome. If there's an agreement, lawyers usually draft it and handle implementation. If not, the case continues in litigation with the possibility of a later settlement or going to trial. Now that we've seen how these stages fit together, let's see how AI, and especially RPS Coach, can help mediators and lawyers improve your work. Coach is essentially ChatGPT plus my work on negotiation and mediation practice systems all rolled into one free AI tool. It's available free of charge as a public service. It's designed to help everyone in the dispute resolution ecosystem, from mediators, lawyers, and parties to administrators, educators, and students. For mediators, it can suggest ways to handle challenging dynamics. For lawyers, it can generate negotiation strategies. For parties, it can explain their options in plain language. Coach draws on more than 200 of my practical and theoretical publications. So when you ask it a question, you're getting an answer informed by my work in conflict resolution, professional practice, and legal education. The knowledge base includes checklists for mediators and lawyers, my co-authored book on litigation interest and risk assessment, and research on how parties make decisions in disputes. It also covers mediation and negotiation techniques and strategies for preparation and early dispute resolution. In short, Coach puts my professional library at your fingertips, available anytime in just seconds. Coach explains what it can and can't do, promotes sound decision-making, and uses plain language that both professionals and the public can understand. It encourages users to see issues from different perspectives, and it offers practical tools and checklists. It helps users analyze possible court outcomes and the parties' interests, and it doesn't rely on any single dispute resolution theory, and it takes ethical concerns into account. Like any AI tool, it doesn't always follow instructions exactly, so it's important to review the output, assess its usefulness, and decide what to do with it. If you're not sure about the response, follow up with Coach or consult other sources. People sometimes say there needs to be a human in the loop. I say there needs to be a human in charge. As we saw in the table in a previous slide, a mediator's work often begins well before the mediation session, and it can continue long after it ends. Before a mediation session, mediators may set the stage by gathering information, learning about the participants, and reviewing key documents. During the session, they guide the process and may help parties analyze their interests and possible court outcomes, manage emotional dynamics, and work to resolve disagreements. If the parties don't reach agreement, the mediator may follow up to see if they'd like to continue mediating later. After a mediation session, mediators also make time to reflect on what worked well and how they could improve their techniques. This list is a short version of a much more detailed checklist in Coach's knowledge base. Coach also includes a separate checklist for lawyers covering their tasks before, during, and after mediation sessions. And the same principles can apply in negotiations without mediators. This list highlights tools and readings to help you in your practice. The 2-page user guide can help you start to use Coach right away. The guide to writing prompts shows how to ask questions to get useful answers. It includes plenty of examples for mediators, lawyers, and parties. The essay on bias explains the values that shape how Coach responds, including its emphasis on professional judgment, client-centered practice, and practical decision-making. The mediation checklist menus offer specific tools for mediators and lawyers, covering every stage of a case. These menus are built into Coach, and you might want to see all the items in these checklists. The article on quasi-mediators describes lawyers who try to reach agreements that serve their clients' interests and that are acceptable to both sides. They help clients understand the other side's perspective and look for reasonable solutions whenever possible, while still advocating strongly if the other side acts unreasonably. Finally, there's a description of the litigation interest and risk assessment book. It shows how lawyers and mediators can analyze client situations and help them make decisions in litigation, negotiation, and mediation. This book is a core part of Coach's training. Now that you've seen the kinds of resources available, Let's switch gears and look at Coach in action so you can see how these ideas work in real time. In this example, I'm a mediator preparing for a session between two manufacturing companies in a high-stakes intellectual property dispute. I want to know what kinds of questions to ask the lawyers before the session begins to understand the parties' goals, legal risks, and emotional dynamics. We'll see how Coach handles the request. Before we run that first demonstration, let me give you a quick preview of the second one. Here, I'm a plaintiff's lawyer representing a client who has suffered significant losses and received a lowball offer from the defense. I want help crafting a strategy to move the negotiation forward, and I also want guidance on how to prepare my client for a realistic risk assessment in mediation. Let's start with the first demonstration. I've already entered the text for this first case into the chat, so all I need to do is click the arrow and send the prompt. On the screen, you'll see 4 conversation starter buttons for people in different roles. So here's one if you're an attorney or a mediator, another one if you're an instructor, trainer, student, or trainee, another if you're an ADR program administrator, and the fourth one is for people who have problems with the disputes or a deal. You don't need to use these buttons. You can just start typing your own prompt. And here we go. I'm going to enter this prompt of the first demonstration. And you can see how quickly it responds. Every chat in RPS Coach begins with some standard disclosures. Coach reminds you that it can make mistakes, so you should review the output, assess its accuracy, ask follow-up questions, and decide what to use. It makes clear that it doesn't give legal advice or act as a mediator. It also warns you not to enter names or other identifying information. After that, it responds to your prompt. All right, so here's the prompt or the response, and it provides a summary. So here are some suggested pre-session questions to ask attorneys. First, to understand the client's priorities and interests. What are their top priorities? Are there non-monetary outcomes your client is interested in? What are the intangible interests? Explore litigation interest in risk assessment, which is from this book that I wrote that I mentioned. And here's a description of what LIRA, litigation interest in risk assessment, is. It's a process for helping people analyze expected court outcomes, financial costs, and intangible outcomes of continuing litigation. It helps plan strategy and helps people decide whether to accept an offer or continue trying to reach an agreement. So under this section, it asks about the elements of this LIRA analysis. Another one talks about identifying emotional or relational dynamics. Assess parties' readiness for mediation. What would your client need to see or hear to consider resolution seriously? A very important question. And on understanding internal client dynamics or internal dynamics and constraints. And then at the end of each response, it asks a questions to see about follow-up. Would you like a version of this customized in a pre-session written questionnaire or as a script? I can also offer follow-up probes. And you don't have to do what it says. You can just type in a response. So for the second one, I'm going to dictate the instructions out loud and have Coach transcribe the prompt, and I can edit it before submitting it. I am a plaintiff's lawyer representing a client injured in a car accident. She has significant medical bills, lost income, and ongoing pain. The defense admits fault, but disputes the extent of the injuries and future losses. They offered $200,000, which is far too low. I want strategies to move the defense toward a reasonable offer and ways to prepare my client for a realistic risk assessment at mediation. Okay, we click this check icon. And in a few moments, you can see that it has transcribed what I just dictated, and you can read it. And it's done a really good job of transcribing. And so now we can click this up arrow and see what it responds. Okay, so it appreciates that you've described your role, and it talks about what your requests are. So here it starts with some strategies to move the defense towards a better offer. Use early, clear framing of your case. Present a compelling, digestible summary of liability, causation, and damages. Emphasize the defense's risk. Draw on the LIRA techniques to highlight the defense's downside. Introduce uncertainty without overplaying your hand. Use mediator leverage effectively. Flag specific settlement barriers and suggest what might unlock movement. Then it turns to the second question you have, preparing your client for a realistic risk assessment in mediation. Your client may understandably focus on her pain and sense of injustice. The goal is to help her make good decisions. So here we start by looking at elements of LIRA, the tangible legal risks and damages calculation. Break down how the future medicals and lost income might be disputed. You might use decision trees or simple bar charts to visualize this. And you can talk about the intangible costs of litigation. People often underestimate the stress and disruption of trial. How would you feel about being cross-examined about your pain in public by someone hired to minimize it? Then talk about some of the non-monetary interests, which you value a faster resolution, structured settlement, and on. And it talks about building confidence without inflating expectations. Avoid telling her only what she wants to hear, and instead involve her in estimating various elements. And then it provides sample questions you might ask and a set of optional tools you might provide. And then it asks if you want to help crafting a mediation memo or scripting parts of your client prep conversation. Now, I've asked Coach the exact same question several times, and each time it gives me a slightly different response. Each response is thoughtful and helpful, but no two are exactly alike. So what can we learn from that? First, AI tools usually don't give identical answers because they are based on probabilities. Second, tools like Coach are best for brainstorming, situations where there isn't one right answer. And third, and most important, it's up to you to follow up on the responses instead of just taking them at face value. This means asking more questions, requesting it to explain terms you don't understand, or telling it when the answers aren't what you need, and then being clear about what you do want. Okay, we've seen how Coach responds to different prompts. The real value comes when you experiment with AI yourself. Start with a 2-page user guide. I'll give you the basics, including a link to Coach. Next, pick a real or hypothetical task and give Coach your prompt. Go back and forth in the chat. Fine-tune your prompts until you get what you need. If the response misses the mark, tell Coach what didn't work and what you'd like instead. When you're done, think about what worked well, what you might adjust, and how you could benefit from AI in the future. Look for the PowerPoint deck, which has links to the resources you have seen. You can also see the chat transcript for the 2 demonstrations to get a better idea of how it responds. This brings us to the end of the video. I hope you found it useful and that it helps you use AI tools effectively in your work. Thanks very much.